My name is Emily Sumner with Sumner Immigration Law based in Richmond, Virginia, and serving clients around the United States and throughout the world. Today, I'm going to give 5 tips for life after receiving the green card. The first tip is one that only applies to individuals who received their green card through the employment-based process. We have so many clients who have waited years and years to receive their employment-based green card, and they're receiving them now, and we are thrilled for them. A common question that we receive is, how long do I have to work for my employer who sponsored me for the green card? The answer is, it depends, or there's not really a specific answer. You will find all kinds of answers depending on who you ask. But in general, you need to have the good faith intention to work for your employer who sponsored you for the green card. So it's a good idea to work for that employer for at least several months, but there may be circumstances where you need to leave sooner. The key thing is that both you and your employer have and had the good faith intent for you to work for them, for that sponsoring employer, throughout the green card process. So a good rule of thumb, like I said, is several months, but what if the company closes or you're laid off? Those are different circumstances, and as long as you can document the circumstances that the company closed or you were laid off or whatever the situation is, then that is evidence that you should keep for if and when you apply for naturalization down the road, the process to become a U.S. citizen down the road. In addition, you need to make sure that you're working in the same role and with the same general salary. It can increase over time, of course, but within the same position that you were sponsored for the green card. And make sure that the employer is paying you an amount that they promised when they filed the labor certification. There is an exception to this if you ported to a different employer, if you used the green card portability provisions, and you may have filed for a form I-485J to let USCIS know that you were moving to a different employer with the same or similar position. Then of course you don't have to work for the same employer who filed your original petition, your original green card process. But in general, you need to stay there at least for several months. Keep that documentation, whether that's pay stubs, W-2s, correspondence from the employer, just in case it comes up as a question down the road. Clients often also ask if they can accept a second job. So keep working for the employer who sponsored them for the green card, but then take on a second job. Absolutely, you can do that. In addition, you can start your own company at the same time as working for the employer who started your green card process, or after you move on from that particular job. Tip number 2 is update your Social Security card. If you have been working in the United States on a non-immigrant visa classification like H-1B, L, E, any of the other different letters, your Social Security card will probably have language that says something like valid with work authorization only. You want to have that language removed because that's no longer the case once you have the green card. And if you present the Social Security card for I-9 purposes, for example, you'll want to make sure to have that language removed. You can contact the Social Security Administration to initiate that process. Tip number 3 is be aware of restrictions on traveling outside of the United States. That is a more detailed discussion than we're going to get into in this particular video, but know that if you travel outside of the United States for extended periods of time, you may need to apply for a reentry permit in order to preserve your permanent residence in the United States. Tip number 4, know who you can and cannot sponsor for permanent residence. A lot of times when our clients receive their green card, they're so excited to be able to start the process to sponsor other family members, and we absolutely are excited for them and happy to help with that process. But know that you can only sponsor certain other types of family members as a permanent resident versus as a U.S. citizen. So for example, in order to sponsor your parents, you have to be a United States citizen. The same thing is true for siblings. You can, as a permanent resident, sponsor your spouse in the future if they're not immigrating with you and if you're not doing following to join type situation. But let's say you get married in several years and you want to sponsor your spouse, you can do that. Same thing for minor children. You can sponsor them as well. Tip number 5 is know when you can apply for naturalization. Naturalization refers to the process of becoming a U.S. citizen. You can apply to become a U.S. citizen once you have been a green card holder for at least 5 years, or 3 years if you are married to a U.S. citizen and living with that U.S. citizen spouse. So again, 5 years just in general, or 3 years if you're married to a U.S. citizen and living in marital union with that U.S. citizen. You can file the N-400 up to 90 days before you meet the 5 or 3 year requirement. There are, of course, other requirements for naturalization, so be sure to investigate those before you begin the process. That's also something that we are happy to help clients out with. It's a joy to help people navigate the immigration process all the way through naturalization. This is not all of the information you need to know, of course, once you become a permanent resident, but it's a good start. Once our clients receive their green card, we send out a comprehensive memo to everyone explaining all of the aspects of the rights and responsibilities for being a green card holder in the United States. I hope you found this information helpful. Be sure to like this video, follow us for more information, and until next time, I'm Emily Sumner with Sumner Immigration Law.